I am joined by a lawyer, Edoigiawarie, for discussion on the 2023 presidential elections petitions as Atiku Abubakar files appeal at Supreme Court. Thank you so much for joining us, Mr. Omori.
Thank you for having
Now, first,
me.
before we get to the issues, this litigation regarding the 2023 presidential election has shifted to the court. What's your overall thought about this?
Shifted to the Supreme Court. Well, it's good for our electoral jurisprudence. As you know, the final court of the land is the Supreme Court, and decisions reached at the Supreme Court are only appealable to God. In essence, they are final. And so there are a lot of pressing issues that this petition, especially at the initial court, have raised, that it will be good for the Supreme Court to make a final judgment or decision on those issues and put those matters to rest.
So it's
a good development.
Right. So let's get to the issues. The presidential candidate of the PDP has now filed an appeal at the Supreme Court. He's seeking nullification of the appeal court judgments. Do you see this happening?
Yes. Well, yes, he wants the decision of the presidential election petition court overturned. Well, the matter is before a court, right? And it would be wrong to make allusions as to where the court will swing. I would rather look at the issues they have raised. They have raised 35 grounds of appeal, stating errors that they believe that the court has made. And I would think that what the Supreme Court would do would be to distill those issues. You have 7 justices this time who will look at it and hopefully address the issues and give full letter of the law to those issues. Whether or not the matter will be trashed on appeal, I believe that the decision at the appeal court, which is the trial court for presidential election petition cases, was sound. I believe that the justices, I addressed the issues as succinctly and as detailed as possible. And I think that the unassailability of certain key things in that judgment, I believe that even on appeal will receive some measure of ratification. But we cannot preempt the decision of the Supreme Court, and parties have just filed. One has not really looked at their appeals succinctly to really understand the basis upon which they are saying that the court has erred. Right.
But some of them are now in this reports that have been reeled out. I mean, 35 grounds of appeal at the Supreme Court. Will that be enough to upturn the appeal court judgment?
Well, it is not the number of grounds that upturn the judgment. It is whether or not you can show the court that the trial court has erred in law. Remember, appeals are not based on facts. None of the parties can bring in any facts. They are only looking at the judgment, and based on that judgment, they are saying that the interpretation of XYZ by the courts was wrong. And we're asking you, the Superior Court, to interpret it correctly based on what we believe should be the interpretation, right? So in simple layman's English, that's what both parties have gone back to court, because just before we're coming in, I got word that even the Labour Party have also filed, and they have 50 grounds of appeal, right? So if you have one ground that is solid and that the courts find merit in, then definitely they will allow the appeal, or they will dismiss. And if they feel that there's no merit, they will dismiss the appeal. But the benefit for our electoral jurisprudence and the benefit for the electorate is that it is important that this matter even gets to the Supreme Court for certain issues to be decisively addressed.
What are those issues?
Right? For instance, the issue of the FCT, whether or not the word "and" means compulsory or whether it's an inclusive phrase. The court will now be compelled to make a clear decision on that fact, and that will put to rest, whether FCT has a special status. The Court of First Instance, which is the Court of Appeal, have said, look, you cannot accord the FCT any special status. They are just as any other state, and so you cannot give them that special leverage. The petitioners are disagreeing with that assertion, and they are disagreeing with the line of the court, right? I think that they feel that the Court of Appeal, even calling such interpretation ludicrous, amounts to a perversive judgment. So it's important that the Supreme Court looks at the issues now. One very interesting definition of law back then in jurisprudence is the prophecy of what the court will do in fact, and nothing more pretentious is what we mean by the law. And so I'm very interested to see how that decision plays out and its impact on our judicial system.
Right, so let's look at what Atiku Abubakar is saying through his lawyers. He's insisting that the tribunal made a serious error in its ruling. But experts say the 12-hour judgment was painstaking.
Yes.
What's your thought on that?
I agree that the court took time to explain. So, elections are very emotional endeavors, especially for everybody on every side of the divide, right? And so if you listen to it dispassionately, I doubt that you will be able to fault the judgment of the appellate court, especially on certain facts. What is playing out, and I think that, and I have said this in other fora, what is important is that we go back and look at the inadequacies, the shortcomings of our Electoral Act, and see those gaps that have now led to some of the issues that we are now having to grapple with. When the Electoral Act was passed and it was being celebrated for allowing for electronic voting, I asked the question, does this act allow for electronic transmission of results? Guidelines do not constitute part of the law. The act allows INEC to make guidelines through which it can carry out its objective as stated in the act. Can those guidelines be interpreted to form part of the Electoral Act? These are very germane questions that we must now ask ourselves. And flowing from this, we must now go back to the drawing board to now see, where does the Electoral Act need some tweaking? Where do we need to rejig? What are the things we need to add? What are the things we need to modify? What are the things we need to expressly clarify? As we speak today, the court has said those guidelines are within INEC's purview. INEC can make regulations to carry out its objective under the Act. They did that. Did they meet it? That is in the Court of Public Record, in the Court of Public Opinion.
Absolutely.
That INEC should receive a few knocks for how this election, or more than a few knocks, for how this election has played out. But let's look at the facts. The guidelines that are being held so tightly to do not form part of the Electoral Act. And so, like I said, let's wait for the Supreme Court to address these issues, and put it to rest. And then after the courts have done their part in the electoral process, then maybe we need to go back to the drawing board and see how to amend the Electoral Act to reflect these issues that have led us to where we are. Very importantly.
So, in your words, if you're saying that the court took time to explain, are you in other words saying the appellants may be wasting their time at the Supreme Court?
No. I will again repeat. It's important that this matter gets to the Supreme Court. Right. Because, like I said, appellates, decisions at the Court of Appeal are lower than decisions of the Supreme Court. Decisions of the Supreme Court become law. And that's what we call judicial precedent, right? inclusive of all decisions of the court are judicial precedent. But where there is a decision of the Supreme Court, no other decision can overturn it except the Supreme Court in another matter reaches a decision that contradicts. And even in that instance, it allows the persons relying on both contradictory judgments to pick and to handpick, right? So it's important that this matter gets to the Supreme Court and they decisively address these issues. It will help our electoral jurisprudence. It will help clarify the issues.
Right.
But I believe that the Court of Appeal took its time to explain its decision, to give a basis upon which it arrived at its decision. And I do not think that it can really be assailed.